Good morning, true crime celebrity friends. We are day 6. The state, I guess, rested on Saturday. I don't know what happened to the live, but mine went down. So I don't know if I don't know what happened, to be honest. So we're day 6 of the Tennessee versus Blaise Taylor. I thought this was a good time to start because they're doing some things about doctors and stuff like that. So I thought we would start from the beginning of the day because I don't think it's really that long. And I hope everyone had a wonderful weekend. My daughter got married yesterday in a small private ceremony. So exciting. Okay. All right. Well, thank you so much for being here. Or if you're watching the replay, don't forget to like, share, and subscribe. And I really appreciate everyone's support. If you could just please give the video a thumbs up or give it a thumbs down. That gets it into the algorithm. So, all right, here we go.
That there was no way that I shouldn't say that she considered and had to rely on the summaries of the individuals who performed the test for litigation package.
What are you arguing about? Chain of custody?
No, Your Honor, the state Smithy, Arizona, in regards there was a surrogate witness that was placed on the stand. After her testimony, it was developed that she had to rely on the summaries of the individuals that actually performed the testing on that vial of blood for 225, 23, and work order number 231. 26889. That is the very vial of blood that the medical examiner relied on in determining the cause of death for Ms. Benning. Given the fact that the expert who testified to the validity, the integrity, and the blood in terms of the cocaine being in the blood, that she was a surrogate witness, it should be excluded after her testimony when she stated that in the amount of time that she had to review all of the data, she had to rely on the underlying test and analysis. Additional to that, she actually testified, I did not look at each quality control. I was not able to actually check each batch. With her not being able to do that, it violated Mr. Taylor's right to confront all of his witnesses and therefore violating the confrontation clause. As a result of that, anything that was relied on by that surrogate witness should be excluded and should not be considered. Without the blood listed in work toxicology report number 231-26889, there is nothing that the ME has testified to that she relied on in order to determine the cause of death for Ms. Benning. In addition to that, there has not been one witness that has come and tied Mr. Taylor to any drug, any form of cocaine whatsoever. There has not been any evidence presented to this court that Mr. Taylor bought cocaine, researched cocaine, did anything of the sort during the
there have to be?
We believe that there has to be a causal connection between Mr. Taylor and the cocaine in order to determine that he...
Just the proof based on who was in the apartment for the 3 minutes between the 911 call and the Ms. Benning's call, isn't it?
I would disagree in that it has not been established by any of the experts that the only period of time that Ms. Benning would have been required to take the cocaine, that it was only within that
There's plenty
period
of testimony that it had been very quick.
However, it did not state that it would have been very quick after she took it, but we don't know when she took it, and we don't know who gave it to her. There hasn't been any
Be
evidence to
somebody in
suggest
the
that.
apartment, or we Danny, or, I mean, that's a jury question.
It is the defense position that no causal connection has been made between the cocaine and Mr. Taylor. As a result of that, in addition to the Smith v. Arizona issue, that there should be a judgment of acquittal, because without a cause of death, then there is no proof evidence that in fact Mr. Taylor could have caused the death of Ms. Benning. As a result of that, we move for a judgment of acquittal.
Okay. All right, does the state care to be heard?
Your Honor, Dr. Mithun was very thorough in explaining that she did her own analysis. She was not a substitute witness, just reading from someone else's report. She did her own analysis. She formed her own opinion. She wrote her own report. It is not even a comparison. Her explanation about that there's no connection to Mr. Taylor and the cocaine, the state submits that there is substantial circumstantial evidence of he is the person who put the cocaine in Jade Benning's drink. Her own words were that she just didn't know what it was. Dr. Carney gave very explicit testimony about timing and that it wouldn't take long to feel the effects. She described dizziness as being something that would be possible, as well as the person might be able to walk, but not for very long after ingestion. And she said that a time frame of approximately 30 minutes until Jade Benning would be in full cardiac arrest, that was consistent with everything that she knew, and specifically consistent with the other autopsy she reviewed. That was the only one that had circumstances similar to Ms. Benning's case. There is I would say proof beyond an absolute certainty that Mr. Taylor was the only one with Ms. Benning in that apartment during that time frame. So the state would ask that their motion be denied.
Okay. All right, at this point, the court relies on the testimony that's been presented by the state. In light of that testimony, the court's discussed already the testimony of Smith v. Arizona issue. There's nothing the court's heard since that ruling that changes that. I mean, Dr. Mithun talked about each batch, but said that didn't affect her reliability of her testing. She looked at a number of them. I don't know if she was asked specifically how many, but, and in terms of the causal connection, something happened to Miss Benning in that apartment. There is circumstantial or direct proof that Mr. Taylor was the only one there, so that's not my role to judge credibility. If they believe Ms. Jackson's statements, then the cited utterance from Ms. Benning tells us who it was. So I'll go over the motion for judgment of acquittal. And who is the defense first witness?
What type of James Smith, you know?
James Smith. Is he here?
He is here, I understand. Really briefly, Your Honor, I think we need to test our computer system before we get to jury.
Oh, I thought that had already been done. The people were here.
We're here. I think we're here. I don't think we tested it yet. I just want to make sure we get it tested real quick.
Turn it on.
Is that your computer?
Yes,
What's on your computer?
it's the PowerPoint that's on the,
Well, your apps are down there.
Yeah.
Your Honor, while they're sorting that out, the one other thing I think we're in a
I think
better,
we're part here. What do you think?
I think we're in a better position to have a discussion with Your Honor about the jury instruction, Your Honor reference 4210A. It doesn't have to be right this minute, but at some point when Your Honor's ready, we can have that discussion.
Do you want it in the jury instructions or not?
At this point, I think our position is we don't necessarily want it in unless there were substantial revisions to it, which we can discuss, but I think as written, we do not want that.
Okay. Well, it wouldn't all come in, it'd be as promoted and intent.
The other concern I will point out, Your Honor, is the language of that jury instruction uses the word crime.
That's why I asked you if you wanted. It could say crime or other wrongful acts.
Our position is that the word crime should be taken out entirely because there is no proof.
I don't know, that's what I said, whether the jury thinks discussing with someone else about facilitating or causing an abortion is a crime or not.
I think there's specific case law that that's not.
So you want it in there if it says other wrongful acts?
I mean,
What word do you want in there?
the closest I think we would, I mean, I think that was our position on this entire form.
What do you want in there?
If Your Honor wanted to charge that, I think we would be comfortable with.
I don't want to charge anything. It's up to you. I'm required by law to put it.
We don't want it.
Oh,
That's our position. Thank you.
what mark on that? Thought he was here.
We don't need this for the first witness, so.
All right, get us Detective Smith.
I get such a bad connection that it doesn't download. So I thought it took care of it. How about the first I'll just use it.
Sorry, let the jury detective. Good morning to you, ladies and gentlemen. The jury, let the record reflect all of the jurors are here and present, and the defense wants to call Detective Smith. You'll raise your right hand and be sworn.
Do you swear the testimony you're about to give to be the truth, so help you God?
I do.
Good morning, Detective Smith. Can you please state and spell your name for the record?
It's James Smith, Jamessmith.
And where are you currently employed?
The Metro Nashville Police Department,
And how long have you been employed there?
nearly 13 years.
Did you ever have an occasion to get involved in this case involving Mr. Blaise Taylor?
I did.
Were you the first officer on the scene at the hospital, the first detective on the scene at the hospital?
I was the first detective to respond.
Did you ever call Andrea Browning and give her permission to go into the house?
Initially, I did not recall that spoke. But yes, been talked about, yeah.
And would you have given anybody permission to go into the house? Is that something you would have done?
The only time that would be done is because I was not doing the search warrant, and the officer I had released, the officer who initially was going to secure the scene or the apartment at that time. He had been released. The apartment at that time had been released, was no longer police custody, to be frozen and such. So to give permission to anybody, it would have been after that fact that I can't say they can or cannot go in there at that time.
And just to be clear, do you have any documentations or recordings suggesting that you gave someone permission to go into the house?
I personally do not.
And would you have given permission for her or any friends to enter into the apartment?
If given permission, it would have just been family. I would have given the family.
And did you give family permission in this case to go into the apartment?
Based off the recollection that was given to me, it would have been either stepmom or mother, but Ms. Browning would have been the contact.
Would an email that you sent refresh or aid in your memory for your testimony here on today?
Yes.
Have you had the opportunity to refresh your memory?
Yes, sir.
After refreshing your memory, do you have any recollection of giving Mrs. Benning's stepmother or any family members permission to go into the house?
Like I said, initially when I sent this email, I had no recollection or memory of giving anybody permission.
And when did you send the email?
This email was sent yesterday, Sunday, June 20th, 2026, around, it would have been 4 p.m.
And did you stand by that recollection?
Not with the information that was given to me this morning.
What information was given to you this morning?
You provided me a transcript. I still don't remember exactly giving the permission. Like I said, it wasn't in any documentation. I don't have a recording. The last recording I have was speaking or interviewing anybody was Mr. Taylor. But it was possible that since you gave me the information showing this transcript that from Ms. Browning that I had spoken to her.
So is your testimony today that you called Ms. Browning and gave her permission to go into the house?
I would say it's possible, yes.
Based on what?
Based off the information that was given to me this morning.
And who gave you that information?
You did.
And the information that I gave you was what exactly?
Transcript from you stated Miss Andrea Browning testifying that I called her.
Was it Miss Browning or was it Miss Burks?
I'm not sure. I recall you saying Miss Browning.
It was Miss Burks.
I'm not sure who Miss Burks is.
Did you ever speak to a Miss Burks?
I'm not sure who that is.
That is Mrs. Benning's mother.
I spoke to her on the phone initially at the hospital. Again, I don't recall speaking to her after.
And that conversation with her at the hospital, do you recall giving her permission to go into the house?
No, not at the hospital.
Thank you.
Any questions from Mr. Taylor?
We can Sergeant Smith, correct?
Yes, sir.
All right. Sergeant Smith, the other patrol, the uniformed officers had spoken to certain individuals, including Ms. Browning, before you did, correct?
Yes, sir.
All right. And if the timing reflects that your conversation with Ms. Browning was approximately 1:45 a.m., does that sound accurate?
Yes, sir.
And again, that would have been after Officer Fish discussed.
Yes, sir.
Interviewed her. And so at 1:45 a.m. and thereafter, you knew that there was not going to be a search warrant,
Yes, sir.
correct? And that there was not going to be any police presence at the apartment, correct?
Correct.
And so legally, whatever, morally, was there any authority you had to tell them that they could not go into Jade Benning's apartment, secure it, and deal with it?
No, sir. Once it was released, I can't say who cannot go in there.
Well, you said released. Has anyone ever actually been there to put up a crime scene tape or stand at the door?
No, sir.
Barring entrance?
No, sir.
And so whether you told her that 1:45 or thereabouts, or later in the call, you had absolutely every right to go there.
At the time, yes, sir.
That's all I heard.
Detective Smith, to be clear, yesterday in your email, you said you did not talk to anyone?
I said, based off my memory and recollection, I don't recall or recount talking to anyone about giving permission to enter the apartment.
And you are aware that your conversation with Ms. Browning, do you know if that was recorded or not?
The initial conversation with Ms. Browning at Vanderbilt Hospital is. Any conversation, again, the last conversation that's recorded in my interviews was Mr. Taylor.
And you would agree with me that nowhere in that recording with Ms. Browning did you give her permission to go into the house?
Yeah, at Vanderbilt Hospital, there was no recording of me giving permission to anybody when I was at Vanderbilt.
And I'm sorry.
You go ahead.
And outside of that recording, you don't have any documentation or recollection of ever giving someone permission to enter into the home?
I don't recall having documentation, or like I said, Mr. Taylor was the last recorded interview I had.
And you do recall that a request was made for the scene to be secure?
I do.
Any other questions?
No, Your Honor.
Thank you.
Thanks.
Who's the next witness?
We will call Sergeant Lindsay Fish.
Do you swear the testimony you're about to give to be the truth, so help you God?
I do.
Good morning.
Morning.
Can you please state and spell your name for the record?
Lindsay Fish, Lynseyi Fish.
And how are you currently employed?
I'm a detective with Metro Nashville Police Department
And how long have you been employed there?
since 2020.
And did you ever have an occasion to make the scene in an incident involving Ms. Jade Benning at Vanderbilt Medical Center?
I did.
And would have been around February 25th of 2023?
Correct.
And in what capacity did you show up on the scene?
I was a patrol officer.
Were you wearing a body worn camera?
I was.
Was it activated?
It was.
The court officer has handed you a photo, and I want you to take a look at it. Do you recognize it?
Yes.
Does it purport to be a still image of your body worn camera from that night?
It is.
And is it a fair and accurate depiction of from your body worn camera that you were wearing that night?
Yes,
Has it been altered in any way?
doesn't appear to be.
Your Honor, at this time, I would ask that this be entered into evidence as a defense exhibit 3, I believe, or what?
Yeah, we're just putting it in that.
55, I'm sorry. Permission to publish on?
Okay.
Can you describe what you see in this scene here?
This is the entrance to the ER of Vanderbilt Hospital.
So this is can you circle this right here? That pole, can you circle it on the screen, please? What is that?
It's a form of metal detector.
And if a guest were to come into the emergency room, would they have to go past that metal detector?
They do.
You see this person with that mask on right here?
Yes.
Can you circle that individual, please? Do you know what that individual is doing?
He is the security officer for Vanderbilt and was checking people in as they go.
And that's what he was doing that night?
Yes.
And to the best of your recollection, was this individual alone, or was there another security guard also present there?
There was other security there.
And to the best of your recollection, were they doing their job?
To the best of my recollection, yes.
Did you ever have an opportunity to speak with a Miss Browning that night?
Yes.
One second, I want to go right back to exhibit number 55. Can you tell me what, if anything, that security guard is wearing on the face?
The mask?
Uh-huh. Is that a mask that they're wearing in this photo?
Yeah.
What about the individual that appears to be checking in? Is that individual also wearing a mask?
Yes.
And so was that a standard protocol and procedure that night that people entering into the hospital with had to wear masks?
Yes.
Now, I just want to try to orientate the jury to, when you say you were one of the first officers on the scene that day,
Correct.
would that mean that you would have come before any detectives would have arrived?
Yes.
Did you have the opportunity to speak with a Miss Andrea Brown?
I did.
And do you know who that is?
It was Miss Benning's stepmom.
And do you
Roll up closer to the mic.
And do you recall while speaking to her that Ms. Burks got on the phone?
I don't know who Miss Burke is.
Ms. Burks would be the mother of Mrs. Benning.
Yes.
She did in fact get on the phone.
Yes.
And you were present for that.
I was.
And what, if anything, did you instruct them while you were in the presence of Mrs. Browning with Mrs. Burks on the phone?
I just informed them of what was going on and asked them if they had any questions.
And did they inquire about whether or not there was an investigation going on?
They did.
And what did you tell them?
I told them that there was an investigation going on.
Did you inform them that detectives will be coming out?
Yeah, I did.
Did you tell them that the house, the apartment should be frozen?
I did.
Did you tell them that in being frozen, no one in, no one out?
I did.
And you came before Detective Smith, correct?
Correct.
And again, when you gave those instructions, Ms. Browning was present
Yes.
and Ms. Burks was on the phone?
Yes.
No further questions.
Question from the state.
Good morning, Officer Fish.
Good morning.
You were just asked if you recall telling them that the scene should be frozen, is that correct?
I did.
Okay. And if your body cam reflects you speaking to Ms. Browning around 12:37 a.m., is that accurate?
I don't know the exact time. But
But it was prior to Sergeant Smith.
yes,
And to your knowledge, Metro Nashville Police Department was going to go out, conduct a search warrant, and freeze the scene.
I knew that that was a possibility.
And if Sergeant Smith's search warrant later got denied, and there's a possibility he told them they could go back to the apartment, would that make sense?
I wouldn't know that information.
Okay. Would it make sense if there was no search warrant and no one was freezing the scene, Metro wasn't there?
Objection, call for speculation. The witness says she doesn't know that information.
Okay, rephrase your question.
Officer Fish, if Metro Nashville Police Department has no legal basis for holding a scene, freezing a scene, if they're not conducting a search warrant, would there be any reason to tell the family that they could not go back in the apartment?
No.
Those were my questions. Thank you.
Officer Fish, do you recall ever stating that you all had information that a possible crime had occurred?
I do.
And that's the information that you gave Ms. Brown, correct?
Yes, that the investigation was, why the investigation was happening.
Fair enough. No further questions, John.
Any other questions?
No, sir.
Thank you. Please step down and be excused. Who's the next one?
The defense calls Leah Gutierrez. We'll move to Dr. Peters. What's the last name? Sheila Peters. Oh, there she is.
Like we approach.
Okay.
testimony you're about to give to be the truth, so help you God?
Go ahead with your question.
Thank you. Could you please state your name for the record, please?
My name is Mia Gutierrez.
And Ms. Gutierrez, how are you employed?
I am a Tennessee licensed private investigator and a Texas licensed private investigator.
And how long have you been a licensed investigator?
In Texas for about a total of 7 years, and in Tennessee, I'm coming up on 1 year.
And did you recently move to Tennessee?
Yes, last year.
Okay. And what company do you work for in terms of for investigations?
Out of Texas, I work for Willis and Associates, and out of Tennessee, it is Covert Results.
And how long has Covert Results been in business?
Since 2017 or 2018, I believe.
Did you have an opportunity to go out to the Ontario apartment where Ms. Benning lived?
Yes,
And when you went out to the apartment, did you have an occasion to view the apartment where Ms. Benning lived?
yes, I did, on the exterior with the door closed.
Also, did you have an opportunity to view the marquee for the apartment?
Yes, I did.
I want to draw your attention. Do you have with you photographs?
I have something else not to put photographs with me.
Should I have photographs?
Yeah. I believe you should have that photograph in your packet there.
Yes,
Okay. Do you recognize that?
yes.
Okay. Can you find that in your packet and can I get my copy back?
I'm sorry, this picture is not in my packet.
Okay, that's fine. Do you recognize that photo that you
Yes.
took?
Yes,
And what is that a photo of?
it is a picture of the marquee of the incident location demonstrating the physical address of the apartment complex.
Okay. May I have it back, please, so that I can publish to the jury? Is it in the same fashion in the way that you photographed?
Yes,
And are you the one who actually photographed this?
yes, correct.
Your Honor, at this time, I'd like to publish. Is that in fact the marquee for the Ontario apartments or condominiums?
Yes,
Have you had the opportunity to view any photographs from 2023 or February in regards to the Ontario apartment complex?
yes,
And is that marquee in the same fashion that it was in 2023?
yes.
Could you please read for us the address here at the bottom of the sign?
It is 1522 through 1550 Lebanon Pike.
Thank you. Did you have an opportunity to go out and look to see apartment 107 where Ms. Benning was living at the time?
Yes,
And were you able to ascertain whether or not Ms. Benning's apartment had windows?
yes.
Where were her windows situated?
On the rear of the apartment.
If I may, Your Honor. Was there anything behind that apartment where the windows were located?
There is a trailer type business, as a trailer service repair business at the rear of the apartment complex. It's rather large, and from my understanding, it's called TSR, and they repair trailers.
I want to first show you this photograph here. Do you recognize that?
Yes.
And what is that?
It is an angle from the rear of the apartment.
And are you the person who actually took this photo?
Yes,
And could you, for the jury, well, let me ask that it be admitted first, Your Honor.
Okay.
Could you, for the jury, please point out which window belonged to Ms. Benning's apartment?
it would have been, I'm not sure,
Mark,
I can mark on here, sorry. It would have been this one.
okay. And I want to now show you another photo. You can clear the screen.
Oh, sorry.
Okay,
Got it.
there you go. I want to now show you this photograph. What is this?
This is a picture of the rear end driveway, you could say, of the apartment complex, coming in after you would come into the apartment complex and then turn to the left. It is a picture of the driveway alley behind the apartment.
And would Ms. Benning's apartment window be adjacent to that, I guess, would it be a pasture or field?
It would be, you could say parallel, yes.
Okay, parallel, thank you. And if you could just orient the jury where Ms. Benning's apartment window would be located.
I can point,
Yes.
okay, it would be this way.
And did you take this photograph?
Yes,
At this time, we would offer.
We'll just make it collective whenever you get all of them you got.
If Ms. Benning was to have a camera in her window, where would that camera, if it was facing out, where would it focus on? Where would it be directed towards?
depending on the range of scope of the camera, it would have captured the entire back alley drive here, or maybe just her back patio, or to where a vehicle could be stationed back there, or all the way up into the trees. It's unsure.
Were there any other windows besides those windows that you saw in apartment 107 at the Ontario?
That is the only one that I recall.
I want to draw your attention now to another photo, if you can clear the screen. What is this?
This is an angle closer to the end of the parking where the truck repair service business is located, just below on the hill.
Is that also behind Ms. Benning's apartment and the view that would be out the only window in her apartment?
Yes.
And what about this photo?
That is another angle showing the trailer service repair business.
Now, did you have an opportunity at our request to do any research in regards to the son of Ms. Stephanie Franklin?
Yes, I did.
Did you determine a name for the son of Ms. Stephanie Franklin?
Yes, the name is Jordan Franklin.
And were you able to ascertain whether or not Mr. Jordan Franklin was in fact a police officer?
Your Honor, to object to the relevance of this.
Your Honor, there's been testimony that a police officer gave Ms. Franklin.
Right, you asked all about it. A police officer told her to do X, Y, Z.
Correct. And if I may, I would like to,
So what do you want to ask?
did you ascertain whether or not Ms. Franklin's son was actually a police officer?
Yes, so to answer the question,
That would be based upon hearsay.
Care to be heard?
Yes, it's not hearsay. She did the record search herself, Your Honor.
Well, I know that, but wouldn't the information be an out-of-court statement offered for the truth?
I don't believe that if you are doing, nobody told her anything. She researched to see whether or not a T-code existed for.
You want to litigate whether the gentleman was or wasn't a police officer.
I think that's very important for the jury to know, Your Honor.
I object. On the basis. Is hearsay.
I believe it goes on the effect of the listener.
Effect on the list.
Absolutely.
Okay, it is hearsay. So I'll sustain the objection.
Also, it goes to 609 impeachment, which allows you to impeach with hearsay.
Based on reliable information.
Correct. And I believe that the information that Ms. Gutierrez received.
You have someone that you're calling from a police department saying he wasn't a police officer.
Yes, sir.
You do.
We have researched and looked
No, I'm
at.
saying, do you have a person from that department?
Ms. Gutierrez called that
I'll
department
sustain the
directly.
objection.
And Your Honor, if I may, through this witness, introduce this judgment.
I certainly object to that.
Okay.
It
The
is-
judgment about.
It's a certified copy in regards to
Okay.
Mr.
Have
Jones.
you looked at the certified copy?
I'm not sure which one
Yes,
is using. We have the one,
here you go. I gave it to you last time, but I'll give you.
but may we approach?
Oh, okay. Any other questions?
No, Your Honor, not from this witness.
Okay, and get those, I think, maybe 5 photos that you asked her about. Get those and we'll make them. 56 collectively. Okay, any other questions?
Not of this witness at this time.
Okay. Any questions from the state?
I would request James.
Any statements you have from this particular witness?
No, Your Honor.
Okay.
May I see the exhibit,
The photos,
the collective exhibit? Yes, sir.
yeah, that's all right.
I believe you said that you were employed by Covert Investigations. Did I get the name right?
Yes, and Wilson Associates.
Oh, okay, okay. And is that based in Texas with an office here, or is it totally Texas?
The Wilson Associates firm is based out of Houston, Texas, and Covert is here out of Nashville, Tennessee.
Okay, and so when were you retained? When were your Covert or?
Are you asking if I've been retained through which firm?
Yes.
Okay. Okay, well, I've been retained under Wilson Associates since before my move to Tennessee on this case.
I was just trying to get the timeline down. And with respect to this particular case, when were you retained?
Covert Results was retained at some point on the case after Wilson Associates, but it's my understanding, to my knowledge,
I start billing.
I'm billing under Willis.
When did you start?
Early 2024.
And what is early 2024?
I would say probably March.
Do you have records there?
Yes, according to timesheets that I turn in, correct.
If you have those with you?
I do not, but I can get them if needed.
Did you have any other involvement as an investigator with this case prior to, when you say early 2024?
No.
Were you familiar with this apartment complex prior to being
No,
retained?
I was not.
Now, Ontario is an apartment complex on Lebanon Pike here in Nashville, Davidson County, Tennessee.
Yes.
And this sign is at the entrance, correct?
At the entrance, correct. Main entrance.
And Ms. Benning's apartment that you were directed to is essentially in the far back corner, correct?
I would say the center far back corner building.
Well, council seen this photograph. They put this view. Actually, it might show better, but you have the ability to text this. Where is the sign that we just saw?
It would be right about here.
Okay, and Ms. Benning's apartment would be in that general area, correct?
No, that would be the entrance to the breezeway to her apartment, but not on that corner.
Okay, well, would you circle in what
It would-
part of that corner it is?
Probably right here towards the center, somewhere in that section.
Yep, another one that's a little bit further out. And this is a larger view of the businesses in the area, correct?
Yes.
And the truck repair place is in the top of the picture, is that correct?
Yes.
And now on this picture, could you circle what you say is Ms. Benning's apartment?
You want me to circle it on here?
Yes, please. And again, circle the entrance.
Where the marquee would have been?
Yes. Thank you. All right, tender these photographs as the next one we do, 58, 57.
there two?
There are two, yes.
Okay, just make a collective 57.
And this is part of Exhibit 56 that we've previously seen. Would you circle again what you say is the window to Ms. Benning's apartment? Now, the next window over, is this also not a part of her apartment, or do you know?
I don't recall, I have to look at a bigger angle. But it is possible.
And obviously, as we see in this picture, the blinds are closed all around, correct?
Yes.
You never went in this apartment, did you?
I did not.
And the photographs that you took, do you know when those were taken, the date and time?
Can I look at my notes, Your Honor?
Sure.
On June 21st, June 24th, and June 26th, just this recent, I visited the property.
Okay. This month,
Correct.
had you visited the apartment complex prior to that?
I have not.
Judge, those are my questions. I'll
Okay.
submit these back.
Any other questions?
No, Your Honor.
Thank you. Next.
At this time, Your Honor, we would submit a judgment.
Okay,
The judgment for Keontae Jones for a conviction of theft on September the 1st of 2022.
okay. All right, mark that as 58. Who's the next one?
The official call about the Sugar Peters Drive.
Okay,
Yeah, I have to do this with my movie approach.
okay. Raise your right hand and be sworn.
Do you swear the testimony you're about to give to be the truth, so help you God?
Yes, I do.
please state and spell your name for the record?
Sheila Peters, SHEILA,
And how are you currently employed?
I am an associate professor at Fish University, and I also operate a private practice,
Private practice in what?
clinical psychology.
Did you have to go through or undergo any schooling for that?
Yes.
What's
Your Honor, objective. You're not calling her as an expert.
This is background information, Your Honor, if I may.
Okay, go ahead.
Did you have to undergo any schooling for that?
Yes.
What kind?
Undergraduate degree as well as a master's and a doctorate.
From where?
Undergraduate degrees from the University of North Carolina in Chapel Hill, my master's and my PhD from Vanderbilt University.
Dr. Peters, have you ever been employed with the Tennessee Titans?
Yes.
In what capacity?
As the team clinician,
And in that role, what were you expected to do?
in that role, I was expected to provide support and assessment for players, coaches, and the entire organization.
And when you say support, what, if any, difference is there between support and clinical work?
My role was to help anyone that was experiencing any kind of distress and determine what their best treatment would be.
Did you ever come to know Mr. Blaise Taylor?
Yes.
How?
During the playing season, on average, I would attend one practice a week, and I would see him as I would see other individuals coming out to practice.
And in those general interactions, what was, if any, your impression of him?
Your Honor, I object to that.
Impression.
We're not having.
They were co-workers, Your Honor. I'm just asking her what was her impression of Mr. Taylor.
With a time frame.
All right, I'll sustain the objection.
When, did you ever interact with Mr. Taylor in 2022?
Just cordial hello.
And did you ever interact with him in 2023?
Yes.
And what was your interaction with him?
I was asked by the GM.
Your Honor, objection,
Okay,
hearsay, and this is in a professional capacity.
If I may, Your Honor.
what is your question?
My question is, did you interact with him at all in
And your answer is
2023?
yes or no?
Yes.
Okay, she did.
And what time frame did you interact with him?
It was in March,
Was it once or more than once?
twice.
Do you recall any dates?
Yes.
What dates would that be?
March the 3rd and March the 8th.
And when you interacted with him, what, if any, impression did you have of him?
And again, Your Honor, I object.
Okay, to get an impression, she'd have to be declared an expert in what?
I'll rephrase my question.
Okay.
What, if anything, did you think of his demeanor when you interacted with him?
Your Honor, I object to what she thought about it, because that would be a
Okay,
clinical
she
assessment.
can describe his demeanor. What was that?
He was concerned about the situation.
That would get into hearsay.
Yes, sir.
So,
She just described his demeanor as concern, Your Honor.
okay, concern. All right, then what's your next question?
And the second time you interacted with him, when would that have been?
She said that already.
Well,
March
did you-
8th.
March 8th.
The second,
And what was his demeanor like when you interacted with him on March 8th?
on March 8th, he was troubled because Ms. Benning.
Yeah, see, you can't get into things he said, and you relied on those to come to that opinion.
Your Honor, I thought she testified that he was troubled, not that he said anything.
If she was about to say that, because of something,
Do you know why he was troubled?
And Your Honor, objection.
that would be based on hearsay. from your client. She says he was troubled, so what's your next question?
And were you there to support him?
Yes.
And how did you do that?
Your Honor, object to the relevance of her support.
Your Honor, that
Did you counsel him? That's a yes or no.
Yes.
Okay, what's your next question?
and as a result of your interaction with him on March 8th, what if anything that resulted from that interaction?
Your Honor, I object to that.
Let the lawyer step up. Any other questions?
Dr. Peters, do you know if Mr. Taylor remained with the Titans after March 8th?
I don't know.
Do you know where did he go, if anywhere?
Sometime thereafter, he went home.
Do you believe that was a good decision?
Well, Your Honor, whether she believes.
Okay, I'll sustain the objection.
When you encountered Mr. Taylor on March 8th, was there anything out of the ordinary with him?
It's been asked and answered.
Okay. How would she know anything out of the ordinary unless it comes from hearsay?
Well, based off of the impression that she would have gotten observing him and interacting with him, what his demeanor may have been.
She's described that as trouble.
She did, but not in relation to what would actually happen when he left. So I think it's a little nuanced there, Your Honor.
Okay, well, I'll sustain the objection.
During your time at the Titans, did you ever have any personal problem with Mr. Taylor?
No.
No further questions, Your Honor.
Any questions from the state?
No, Your Honor.
Thank you, ma'am. You can step down. Who's next?
At this time, Your Honor, the defense will call Dr. Melissa Jerry.
Jerry.
Your Honor, at this time, pursuant to previous discussion, sacred request and carry out, because we have no report.
All right, ladies and gentlemen, the jury, if you'll step down the hallway just briefly. Okay, what is it? Hang on a second, ma'am. What is this witness being offered for?
This witness is being offered in regards to the NMS reports. To the NMS reports that were tendered to the defense in regards to the blood and urine of Ms. Benning. And the testing of that blood and urine that went to the cause of death in this particular
And
case.
you're wanting her declared an expert in what field?
And laboratory testing of toxicology.
Is she a toxicologist?
She is.
Okay. And the state's objection is what?
If we have no report, we have her CV, but no report to know what the parameters are for.
Do you have a report from her?
She didn't give a report. She looked at the
Notes?
Yeah.
Do you have any report? No, I'm asking you, do you have any information from her that would be considered a statement?
I don't, Your Honor. I asked
I'm not
her.
talking about you, I'm talking about your firm, your counsel.
No, I am the from counsel. We don't have anything. I've met with her on several occasions. I have my work product, but I don't have any notes from her.
So she's never emailed you or anything like that?
Of course. But it wasn't a report.
Her notes.
I don't have notes from her. She may have emailed me in regards to what time is the Zoom call, or are we?
She didn't have a report.
No.
So what do you want me to do?
We would hear her testimony out of the presence of the jury for the court to determine whether it will materially assist the jury and basically obtain a hearing.
So you're thinking this particular witness isn't qualified as a toxicologist?
No, it's the substance of what she testified about that we have no knowledge. She just now says about NMS. Well, if we had a report, we might know whether to have.
Some people don't do reports for tactical reasons.
Yes. And here, since the witness has a notebook with her, that might be some, there's nothing else, jinx material that we would.
What is all that?
Your Honor, it is my brief notes to prepare for testimony today and the NMS reports that were provided.
Okay. Do they have a right to look at that?
Sure.
How long do you need to do that? See, the jury's back there thinking, I won't say what they're thinking.
Prior to the last trial, when we had this come up, certainly recall that the court said witnesses would be excluded if they did not prepare a report. And here we are now without a report.
I don't know if I said that.
As well as counsel saying that they were only intending to call Eric Dallin.
Well, I don't know who that is. I mean, this person's listed on this witness list.
We have provided the state. We have provided the state a full list of all of our experts and a brief summary of what they are to testify about. The rules and the statute does not require that every expert draft a report. Any notes that Dr. DeGary may have, I don't have those notes. And they're more than willing to look at whatever notes that she's made in order to assist herself in this testimony in the same manner Dr. Lethune had to give me notes when she turned over almost 10 pages of notes to
Do
me.
you have all of your notes pulled out?
The records.
Do you want to look at those, the state want to look at those before she testifies?
Yes, Your Honor.
Okay. Run copies of those, Mr. Evans. And of Dr. Bartolome, Dr. Larkin, and Dr. Lindsay. How many of those do you plan on calling?
All of them.
Do they have notes?
I can find out.
Do they have reports?
They do not have reports. All of our experts, Your Honor, reviewed all of the toxicology reports in this case. There were almost 13 toxicology reports in this case that needed to be interpreted. There were litigation packets that went along with those toxicology reports that were out of the purview of counsel's knowledge. We're not scientists, so we had to actually confer with experts in order to understand the science in this case.
Sure.
And so we hired experts to assist us to do that.
Could you have someone get from those other 3 doctors their notes that they would be using to testify?
I certainly can.
And get those to the state?
I certainly can.
All right, go ahead and do that. How long is the state meeting?
We were very much under the impression, based off of your Honor's prior rulings in the hearings, that if they did not provide us reports, their experts would not be allowed to testify. We would have had Dr. Mithen stay so that she could be in the courtroom and listen to this, so that we could recall her as a witness. We are without our experts, which is exactly what we said when we asked your Honor to exclude them if they
I don't
did
think I
not
can
provide a
exclude
report.
them when they don't provide a report. The rule talks about turning over a report discovery if there is one.
And the state didn't give us notes of all of their experts.
They got a
I don't know.
litigation packet, that is their note.
Said you had 1,300 pages.
We asked for that litigation packet and paid for it ourselves. The state did not provide it to us. We provided it to them.
You want time to get Dr. Carney or anyone else up here?
Those are toxicologists in Pennsylvania.
We never said we
I
wanted.
didn't ask you to say anything. But what do you want me to do? Declare a mistrial? Delay it till next Monday?
Would your Honor allow us to contact Dr. Mithen and see if she is available to watch it by video, so we can at least confer with her after this witness testifies? If she was present today, she would be allowed in the courtroom.
Sure, she can go on, as I'm understanding it, live streaming and watch it.
May I step out to get in touch with her to see if she's available to do that?
All right, get those other notes. We'll be in a 15-minute recess.
Hi. Oh, I'm okay. So, bad news. Amy and Haley, everybody's got to re-sign the license. Because of Haley's deed. Because of Haley's messed up deed. Down today. So I'm going to make them cinnamon rolls to take home.
Is the state ready?
Yes, Judge, we were just, honestly, to expedite the process, we are no longer asking for the jury out. We have our toxicologist that's on the link. And we won't, if your Honor's going to allow the witness, we won't object.
Okay. I mean, if you want to be heard under qualifications and all, then I can do that.
Not as a jury.
Okay. And then if Dr. Minton is to be recalled,
I don't know, I haven't heard anything. I don't know nothing.
Which means, we would like notes and emails as well, please.
what are you talking about?
I said, if she is, so that we can get ahead of it, we would like notes and emails as well, please.
Notes and emails about what?
Her testimony and her notes, and
She would be, as you said, offered as rebuttal.
and I would like those.
Raise your right hand, we'll just bring the jury in.
But we just got handed, are these more notes for her?
Shut the door there. Did you give them earlier when we were in here all of your notes?
That I had with me? Yes.
I have 4 pages that she handed us.
What is all of this?
I just got handed this.
We printed what you asked us to print, the notes.
For this witness?
Yes,
I thought she provided it.
you wanted emails, so by you.
No, I didn't want emails.
You
I
asked,
asked her for notes.
she gave her notes,
What are these?
my email.
These
I
are not,
didn't ask for emails.
these are not emails. I just got a whole stack of notes.
What is all this stuff?
That was you had asked earlier if I had sent her work product of what I was doing as I was reviewing the data, and that's what that is. That's what I sent to her a long time ago prior to preparing for testimony. This was my analysis of going through the data.
So she did give you notes.
Sounds like a report.
Let me see what you have, I don't know what you have.
That's not,
That's what you emailed them, and somebody printed these out for me.
it's not a report. There's not an opinion in it.
Your Honor, the state renewed our
This is
objection to
this
this witness.
This is the exact same thing that is a snip of the litigation package. It's all it is. And then
Can you determine whether most of that is from your witness's litigation package?
There's only, I think, the last 3 pages of this. This is
And then
all
what's the other
notes.
stuff?
May I explain to her what she's looking at?
I'm asking counsel.
If you look, all of this are snippets of the litigation package.
Is all of this snippets from the litigation package?
All of it is derived from the litigation.
And then
What do you
there are
mean
notes
derived
on top of it.
It's notes on top of it of what I was
From
seeing
who?
from me as I was
Why didn't you
looking.
give us that earlier?
I didn't have it, sir. I don't have
See,
it.
this is what hide the balls off. You know, I got a jury back here, guess I'll direct myself to you, that's thinking I'm an idiot because of this trial. The procedure, the logistics, and they're back there wondering what in the heck we're doing. That's why, you know, the intent of Rule 16 is not hide things.
I'm getting the notes in the same number that they gave
Why
to
didn't they
me
give
with
them?
Dr.
I'm not worried about how they
Miller.
gave them to you. I'm dealing with how you gave them to them.
Well,
Do you think, Mr. Brand, Rule 16 doesn't include providing these notes pre-trial?
no, he did, and so.
No, he didn't. Y'all didn't. I'm asking him, do you think Rule 16 would include, when it says copy, photographs, documents, reports, and provide the other side, if you've requested discovery. Did that include this stuff?
No, Your Honor,
How so?
because I think that's probably James material, under 26.2.
But they're reports from what you're proposing to be an expert.
I don't think that's a report, I think it's her working notes as she's reviewing the material, which could be James material, but is not a Rule 16 report.
See, that's the problem with efficiency, which I hate inefficiency.
I appreciate it.
So, do you need additional time now?
Yes, I would like for my expert to be able to have this. I just got handed it as she was.
Can you email that to your expert?
Completely disorganized.
Judge, I submit that what she has provided is a report that she provided to the defense, and she just said it was a while ago, and the defense did not provide it. We filed a motion to exclude and asked Your Honor to exclude any witnesses that had not provided us with a report pre-trial.
They're saying that's not a report.
I mean, do we need to have a jury out to determine if it is? If it is a report, is Your Honor gonna exclude it?
Sure.
Then I would ask the witness, there be a proffer to the court for the court to make a
That
determination.
can copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions thereof, if the item is in the defendant's custody and intended to be introduced as evidence in their case in chief.
This is not being introduced in our case in chief.
That makes no sense.
Well, it's not being introduced for our case in chief.
So you want to orally ask her all about it and then just.
I'm not moving the same manner that General Norman did.
I'm not dealing with that. I'm dealing with, have you complied with Rule 16?
Yes, I have.
So you're not going to ask this witness to introduce anything?
No, I'm not.
So what do you want, General Norman?
Well, honestly, I gave somebody my paperwork to go copy it and send it to our expert.
I thought you got an email with that in it.
I haven't even had a chance to look at it, but what the little I looked at, it looks like she typed up a report.
It's not a report.
Where is that? Where's the copy I gave you?
Here it is.
What page in that are you thinking is a report?
There's one that has like 7 or 8 pages and a couple of pages of litigation packet in the back.
So I'm not worried about the litigation packet.
I'm not either, it's everything that precedes it.
It looked like, I don't know, what, page 47, 48, what are all these notations for the litigation packet?
Yes.
Page 50, 51, so that's just a summary of what she's looking at. 69, 75, 81. How, Ms. Hahn, is this not a report telling you what she's finding in the medical records?
She is regurgitating what is in medical records. It is not an opinion. She's not a doctor. So where she can't give an opinion on a medical record.
Well, it's saying here,
And neither are we planning on introducing it.
page 75, instrument had an error, incorrect vial, not on our case. What's she reporting to you?
What's in the litigation package? That is not her opinion, that is directly taken from the litigation package.
Okay, what do you want to do, Joan Norton?
Judge, I mean,
Testify.
I think the witness should be excluded.
Okay, other than that, what do you want to do?
I would ask the court to give us 5 minutes so I can at least have the paperwork in front of me before she starts
Did you
testifying.
get this document through an email?
I don't know. She handed me documents, she emailed me documents. I'm
It
asking
was an
that
email
all,
to the court?
I asked
Were you
all
not
of it
in
be
on it?
printed. I'm saying I don't think they're the same things. What she handed us and what she emailed us, they are printing it right now.
The emails that I sent over are nothing but logistics. I sent them over because the emails.
Sent them to who?
To
No, I'm
Joe.
not talking emails in the past. I'm talking about, did you email this packet to the state?
I don't know.
Yes, Your Honor, I believe that the packet that you're holding is included in the email to the state that has
Did you get this
several
by email?
Word documents.
I received an email with 7 attachments that say summary of lit package, which sounds like a report. If she is not introducing anything, then
Do you want to forward this to your
yes.
Dr. Can you do that?
I have forwarded the email. I'm asking that the printed documents, which don't appear to be exactly the same, be scanned in so we can send that, and that's happening right now.
How did I get this if it's not included in an email?
I'm saying she handed us documents and the emails look like there's additional things.
Who handed you documents?
They did, right when she was walking out to
Was
the
this
stand.
packet sent to the state as an email?
Yes.
Yes.
Do you have that?
Yes, Judge, I received it a few
Okay,
minutes
can you
ago.
forward that to your expert?
I did.
Okay. All right, so do you need additional time?
I would like to have a copy, but I guess.
Oh, okay, give that to the state. So do you want additional time?
No, Your Honor.
All right, let the jury step in.
Judge, just before they get out here, the state is going to object to her testifying to anything related to any report that was not introduced as evidence in the state's case in chief. She cannot introduce NMS reports that have not been introduced.
Okay,
And so,
these two binders,
no, those are the medical records.
okay.
So their NMS did more testing than what was introduced in our case in chief, and I'm objecting to her testifying to any reports that were not testified to by Dr. Mitten and entered as evidence because it's irrelevant to this proceeding to talk about other tests that were not presented to the jury.
Okay, do you agree with that, Ms. Holland?
I do, because we're only
Okay.
talking about the two.
Good, then we don't have a problem.
Testified.
All right, Thank you for your patience, ladies and gentlemen of the jury. Ma'am, if you'll stand up, raise your right hand and be sworn.
Swear the testimony you're about to give to be the truth and the truth.
Yes.
This one. All right. Okay.
Good afternoon, Dr. Gary. How are you?
Good, how are you?
I'm good, thank you. Could you please state and spell your name for the record, please?
Dr. Melissa Jagir, Melissa
And how are you employed?
I am currently an independent contractor for forensics toxicology and science.
And where are you in terms of company that you work for? Who do you work for?
I currently work for a company that I own. It's MG Forensic Consulting.
And how long have you been a toxicologist?
I started doing toxicology in 2014.
And where did you go to school?
I received my Bachelor of Science at the University of North Texas, and I also received an Industrial Master's from the University of North Texas in chemistry. An Industrial Master's is different than a regular Master's because I did not have to do a thesis. I had to be working in the field and had to write my paper in regards to what I was finding and doing the lab work in the field. And then in 2023, I graduated from Oklahoma State University with a Doctor of Forensic Sciences with an emphasis in toxicology. It is not a PhD, it's a professional doctorate. The difference between a PhD and my doctorate is I didn't have to write a dissertation. I had to be employed in the laboratory, and all of my papers were based on data that I produced while working in a laboratory.
And how long would you say that you worked directly in a toxicology laboratory?
Just over 10 years.
And have you been peer reviewed with your work? And have you also peer reviewed others and their work?
Are you referring to peer reviewed and just releasing my data and someone reviewing my work prior for release?
Yes.
Yes, I've done both ways.
At this time, we will tender Dr. Jagari as an expert in laboratory toxicology.
Any questions on that request from the state? All right. Ladies and gentlemen of the jury, would still allowed to give an expert opinion in her field. Like I told you before, you can place such weight on it as you choose.
And do you have a curriculum vitae in regards to your training, experience, and education?
Yes, I do.
At this time, Your Honor, I would tender Dr. Jagari's CV.
All right. You want her to see it?
No, just tender.
Okay, just give it to the clerk for 15 minutes.
Dr. Jagari, have you had the opportunity to work in labs that are accredited by the ANAB?
Yes, I have. I did my full 10 years working with an ISO ANAB accredited laboratory.
And what exactly is ANAB?
So ISO 17025 is it's an international standard that people who do qualitative, quantitative results have to follow this standard. It is, if you look up pharmaceutical companies, petroleum companies, they follow it as well. So then you have ANAB, which is a subsidiary more for forensics that you have to follow. And so it gives a little more guidelines to be more for science versus petroleum or some other company that could have ISO. But then it goes a little further, it goes into ASV, which is an American Standards Board, and they produce guidelines and standards specifically for forensic toxicology. So you have a blanket overview and then you kind of narrow down into a funnel from there.
And can you tell us some of the things that are required in order to be accredited? such as chain of custody, such as keeping things stored at proper temperatures and things of that nature?
Sure, so the accreditation is very, the ANAB standard itself is very bottom line. It's very minimum, and it says you have to maintain a chain of custody. You have to monitor your refrigerators, and it should be kept between this temperature to this temperature. But you get those more finite details in the American Standards Board standards, those ASB standards. ANAB is more of a general. It's you have to do this, but you should try and go better. It's the bottom line of what it is. And so you have to maintain chain of custody. You have to document all kinds of everything in a forensic laboratory. You have to, the bench notes that as you're working through a case and you take a bench note, you write down it's oily or it smelled funny or whatever, that has to be maintained with the case file as well. It also goes through guidelines about who's allowed to work on it based on credentials. It goes through who has access to certain areas. It restricts that. It doesn't restrict it, let me clarify that. It dictates how you should document who has access. It's more of a documentation aspect from ANAB versus the recipe on how to do things.
And why is that important?
Forensics is the way I look at it, has three pillars. You have integrity, you have chain of custody, and then you have unbiased opinions. And you have that as a three pole and a stool. If you lose one of those, then you kind of wobble and you kind of can lose the reliability of the forensic analysis that you have. And so those guidelines between ASB, ANAB, and ISO all help to make sure that that stool is good and stable and it can be reliable and accurate at the end of the day.
So I want to draw your attention to the NMS lab report number 231-26889. Are you familiar with that toxicology report?
Yes, ma'am.
Do you have a copy of that report with you?
Yes, ma'am.
How many reports were issued under that work order?
I just have the one that was originally provided to defense that was dated 5/16 of 2023.
And have you recently been made aware that there was a new report issued on June the 10th of 2026 in regards to litigation packet 231-26889?
Yes, you informed me of that.
I want to talk to you about whether or not when you did your analysis, well, let me ask you this first. Did you do an analysis of this particular toxicology report?
I wouldn't call it an analysis in the sense of science. That's doing actual chemical extractions. I did do a review of the data.
Okay.
Sorry.
I need to get with your terms. So tell me, what, if anything, did you learn after reviewing the data in regards to work order 231-26889?
So when I first reviewed it, what first caught my eye was, we can see at the bottom it says specimens received, so that's what I go to look at. Typically, if you're looking at anything for blood,
Work. Don't worry, I can use this. My computer doesn't like that. Can I switch? We're gonna end up having a problem with it, so don't worry about it.
My witness is not in the feed. It keeps hanging up and she's not able to view what's happening.
He said that some of the witnesses in that he can hear.
It's not that she can't hear it, it means the way that it just lags and freezes up, so it's not just hearing, it's freezing.
That is her internet and her buffering, not.
You wanna go out and call her and see where she might be or relocate?
Hunter, is there any way that Dr. Midday could just have an audio line? I mean, how do you do it on the cell phone?
Ladies and gentlemen of the jury, if you'll step back down the hall. I don't know of any way to do a Zoom link and do additionally what we're talking about doing in this trial. Is she somewhere that she can relocate or get better internet?
She said she tried it on Wi-Fi and also her cell phone. She was in the car driving and drove to a location so that she could do this. She said if she could just be on a phone line so she can hear what is said, that would be sufficient. Is that a possibility?
I don't know how well she'll be able to hear if we call her from that phone right there. As long as she's not speaking.
She wouldn't be speaking.
You want to come punch in her number? Hit speaker.
Dr. Connolly, this is Carrie.
Dr. Smith, this is Jean Norman. Can you hear me?
I can, yes.
So I have you on the phone report.
Okay.
Can we ask the witness to say something to see if she can hear?
Can you hear me, doctor?
Yes, I can. It's a little difficult, but I can hear you.
Okay, can you turn the volume up on all the mics? Can you state, can you state your name, please, ma'am, for the record?
Melissa Jaguar.
You'll have to speak up into that mic.
Melissa Jaguar.
Can you hear that?
Yes, that's much better. Thank you.
All right, bring the jury back then.
Judge, Dr. Mendon couldn't hear the report number. Can we just let her know that we're talking about 2312688?
231
2688.
26889. Okay. All right. Go ahead, Ms. Collins.
Dr. Jaguar, we were talking about litigation packet toxicology order 231268889 from NMS. Can you tell the jury what sample of specimen is this referring to?
You'll have to speak into the mic.
It's referring to the clear plastic top tube with 1.75 mils that was collected on 2/25/23 and at 22:31 or 10:31 p.m. labeled hospital blood. And it also includes a clear top plastic tube, 8 grams, collected on 3/7/2023 at 13:34 or 1:34 of liver tissue.
Now, we see there on this report that number 1 is a clear plastic tube, which is self-explanatory. But could you tell the jury what is ID 003, homogeneous container?
So as you heard from Dr. Methune, that's where you take it and you blend it essentially and make it so you can, in analytical chemistry, you have a thing, it's called an Eppendorf pipette, and you have to draw up a specific certain amount for the test to be accurate based on validation. And so you have to make it to where you're able to draw a liquid into this little tip to be able to start the extraction. So the laboratory took, I don't know how much, usually it's documented, but you take a portion of that, you weigh it on an analytical balance, and then you mix it, in my experience, we've mixed it with water, and we put it through a blender, better way to think of it, and you hit go and it blends up the tissue to make it to where it is more pipettable for the equipment.
And we see that on item 2 and 3, it notates liver tissue. Do you know whose liver that this report is referring to?
I do not, because the labeled as number is the same. So I would think that I interpreted this when I was first reviewing that the liver was from the same person with the hospital blood.
And whose hospital blood does that belong to?
Based on the review of the medical record, that it was tied to a Jade Benning.
Have you since learned who the liver tissue belongs to?
Yes, it was discussed that it was belonging to the fetus of Miss Benning.
Have you, well, in preparation for litigation, Is there something that NMS will provide to attorneys if the attorney requests it?
It's called the NMS litigation packet. You've heard about talking about litigation packets.
The answer would be either yes or no. Did you get that?
Yes.
And can you tell the jury exactly what a litigation packet is?
Sure. So a litigation packet is a copy of the report, followed by a copy of their receiving data, where they start their chain of custody. It also includes the summary of who would have touched the sample along the way. It also includes the, if there's a disposal, there's a communication log, anytime that there's a communication regarding to that particular case. Sometimes there's also emails that are included in it that are not in the communication log, just within their own departments. Also included in that are all the testing that was completed for that case. So in this case, I believe it was around 1,900 pages to review. You have every test that was ran on it. You have all of their standards, which are the calibrators, which allow you to put a quantitation number to something. It also includes the quality controls, and it includes this case specifics data.
And did you have an opportunity to review the litigation packet for toxicology report 231226889?
I did.
What, if anything, did you find as a result of reviewing that report?
That it, looking at the, and I don't have it up here, I didn't bring all of it, but the request was signed to be relinquished from the medical examiner's office on 3/31. It was received at NMS, I believe, on 4/4. With any kind of blood sample or even just tissue, anything that's biological, it needs to stay refrigerated. For multiple reasons. It helps to slow down any kind of growth or breakdowns, preferably to be frozen, but it helps to reduce that. And then looking at when it left the medical examiner's office, I presume it arrived with the body. Part of my past experience is I did medical examiner work, and we would get antemortem tubes with our postmortem samples to look at and compare. And when we would get that, they would be multiple tubes to choose from. And so I don't know if there were multiple tubes in this case, and this is the one that they chose. But it was collected on 2/25, and it doesn't, and as far as I can tell, arrived to the medical examiner until 3/7. So I don't know how it was stored, who had access to the sample. It was collected for medical purposes. So I don't know what was done at the hospital for testing, opening, who had access to it there, how much blood was removed, did they spin it down at all? Anything that could have happened to that tube prior to it arriving at the medical examiner's office.
Are you stating that you found that there was an issue with the chain of custody with this particular sample?
Yes. And the medical records also state that they couldn't identify a chain of custody, which is why they contacted the PD to have the PD come draw their sample to establish a chain of custody. And that was after the sample.
So did you ever find in your review of any of the materials, anything that could establish a chain of custody that would be sufficient, in your opinion, in regards to the ANAB standards?
The laboratory maintained a chain of custody, and that's where the chain of custody started.
What about previous to the time before it got to the laboratory or arrived there?
I don't believe I've had any documentation for that.
Was there anything else that you noticed about this laboratory report that you found issue with?
I notated that there was no seals on the tubes when they arrived at NMS. There was no evidence tape over it. There was nothing to seal it. Not saying it was open and spilling everywhere. I'm not saying that. The sample would have been closed because there was notation of no spillage. But there was nothing over top of the tube
and a date and an initial to make sure that it hadn't been tampered with or hadn't had anyone had access to it prior to it arriving to the laboratory.
Is that something that ANAB requires of an accredited laboratory?
No, it doesn't require it to be that. It's just required that they document how it was received.
What do you find is best practice when you're dealing with these types of forensic toxicology tests, especially in criminal cases?
In my experience, we've received our samples for forensic toxicology to be sealed, dated, and initialed by whoever collected it for the integrity of the sample.
And was that done here?
It was not.
What type of tubing was the blood or the vial of blood? What type of tubing was it packaged in?
It was in a clear plastic tube, which would have no preservatives. So if there was a dirty collection, meaning they didn't have the site clean and some bacteria got in, there's nothing to even slow down bacteria growth or bacteria formation. And there's also nothing to slow down or retard any of the degradation of any of the drugs that would have been present.
Are there, if you can educate the jury, and we've all had our blood taken before, are there different types of tubes that are utilized to preserve whatever the sample is, whether it's blood, urine, whatever that is? Are there different type of tubes for that purpose?
Yes, there's different color top tubes. Ones that I'm familiar with from working in the laboratory, we sell tiger top, we sell blue top, purple top, and those are all unique to the medical field of what they're looking for to test. So each of those have a different preservative in them depending on what the medical need is out of that sample. The most common one used in forensic toxicology is the gray top tube because it has potassium fluoride or potassium oxalate and sodium fluoride, and both of those help to slow down or retard the formation of bacteria, as well as help to preserve the blood specimen as best that it can.
Now, was this sample actually preserved with the proper tubing?
Not for forensic testing.
So did you find that as a result of the issues, well, let me ask you this, were there any other issues that you found with this particular vial of blood?
I think that those are the main ones that I found.
At some point, were you able to ascertain the levels of concentration for this particular vial of blood in terms of what it was looking for? What exactly was this test looking for in regards to this toxicology report, I should ask?
So it was looking for cocaine in the products, which is what it's listed as, which is the cocaine and the metabolites. And the blood was also looking for designer opioids, which are going to be looking for your more typical illicit fentanyls and illicit opioids. This did not look for the actual drug of fentanyl.
And so are you stating that when we see the test, that does not include fentanyl?
It does not.
Did you see anywhere in this particular report where it was asking for a fentanyl test?
I do not, and they also didn't order a general screen that you typically see with forensics postmortem that we saw in the liver, which is a very broad, looks for multiple substances. And I believe there was a note in there that it was a direct reflex for cocaine in the designer opioids because they were nervous about the volume of blood that they had left for testing. So they directed the sample instead of taking out of the normal flow of how a sample would have been received and processed.
And were there results as a result of the testing for this particular report? Did it yield any results?
It did.
And what results did it yield?
We have benzyl-econone, which is the first major metabolite out of cocaine, and cocaine, which is the parent drug, and then ergonine methyl ester, which is a secondary metabolite out of the parent cocaine.
Was there anything else of consequence that resulted out of this blood as a result of the testing that was performed?
So the things that are reported are things that are above their, what they call the LOD, the lower limit of detection, or the LOQ, which is the lower limit of quantitation. I'm not sure, it was not provided their SOP or their validations for these methods, so I don't know if those are one and the same. Some laboratories, their LOD and LOQ are the same. Then what that means is that the instrument cannot look below that quantitation level or that limit of detection and be reliable. And so I don't know if that included that, but in my review of the data, I actually did find that there was some of the metabolites that were present that were just not above the reporting limit, so it wasn't reported, but there was presence of an indication of in the data.
And what exactly did you notice that was present in this particular report that was not reported?
So in this, it would be the item number is 1A1, and I can identify it because it has a 001. So if we go back to the first page, and we saw that the clear top tube had 001 in front of it. That is, as I review the data, everything that I find that has 001 is tying it back to that specific item. So I'm not mixing up that with the other liver item or the homogenate. And so I was, there is presence of coca-ethylene in the windows. And if it's not there, then the window should be just a flat line. There should be no coloring of the little mountains or peaks in there. But the,
is this?
No, that's 285.
I apologize.
That's okay.
Let me make sure I have the right one. So, did you find in fact coca-ethylene in that report?
I found indication of. I will also say though that the, you'll pull up so I can, up or down, sorry. Over to the right, that's the comforter.
Okay.
And so the ion ratios though on this are out, however. And what that is important to also note that even though it is in the window, the ion ratio is out. So it was below the reporting limit and it had another criteria that was also out for the reporting limits. But this was a very low sample and it was very, I don't know what all had happened to it prior to, so if we would have a full sample, I don't know if those ratios would have been able to be in, because I would have had the full sample instead of having stuff removed, because I don't know what the hospital took, and I don't know what the hospital did to that too prior to it being there.
Okay. And so did you in fact find a notation or an indication, if you will, of coca-ethylene?
Yes, it is present in both windows of the, there's a transition, you have a main transition, and you have a second transition, and it looks at, for lack of better understanding, you have my water bottle as one transition, and you have this cup as a second transition. You look at this ratio of the height between the two, and that's what it's talking about the ion ratio. That ratio needs to be consistent to call that drug. But just because it doesn't have the ion ratio, it should lend to further testing to look and see if it is actually present or not.
Would this be the correct?
No, that's 183.
Okay, sorry about that. So, but you can tell us that it was in fact an indication of coca-ethylene in this report.
There's indication in both windows, yes.
Now, you stated that the ion ratio was out, is that right?
Yes.
And so how can you then tell this jury that coca-ethylene, there was some indication of it?
The ion ratio being out doesn't mean that the instrument didn't see the analyte. The instrument saw the analyte and was able to generate a indication or a peaks in the window. If it wasn't there, it wouldn't have a peak in the window.
Okay, and did you in fact see a peak in the window in this particular testing?
I saw indications of yes.
Okay. What does that tell you in regard to whether or not coca-ethylene was present in the blood of Ms. Jade Benning?
As I said, it would just draw me to do further testing. With the ion ratios being out below the reportable limit, it would definitely cause me to run the test again, see if you can do microing, you can pull it down and reconstitute it and make it at a stronger concentration, and then rerun it and see if we would be able to obtain a value or not, to prove if it was there or not.
So if I draw your attention here at the bottom of page 3 of 4 of this report, do you see where it states coca-ethylene here?
Yes.
And is this a confirmation test?
Well, we're looking at the liver. You need to move up a little bit.
Sorry about that.
Okay, yeah.
Okay.
So this would be a confirmation because we can see that it's the liquid chromatography tandem mass spec. And that's where we're able to get the 2 different windows to see the transitions based on the instrumentation selected here. If this was a screen, it would have been an ELISA or an immunoassay type test.
So before they move to a confirmation test, what type of test do they perform first?
Typically, you would do a screening test, but in this case, I believe it went straight to confirmation. So they skipped the screening test and went straight to this test to look for the drugs.
Thank you. Are you familiar with coca-ethylene or the metabolite coca-ethylene?
Yes.
What is that?
It's a metabolite that is made only in the presence of ethyl alcohol and cocaine at the same time, and it's made in the liver.
And is there any other way, to your knowledge, that coca-ethylene can be formed in anyone's blood or urine or any matrix that you know of?
No, and that's what makes it unique about coca-ethylene, is the only way it is produced is with mixing cocaine and ethyl alcohol, or what we would call alcohol in our normal language, and it has to be at the liver at the same time.
And there was indication that here.
Yes.
Did you find that there were indications, and just so that we're clear, at what time was the blood sample taken for toxicology report number 231-26889?
10/25/23, 22/31 military time, or 10:31 p.m.
And did you have an opportunity to review the medical records in this case?
I did.
And did you find in the medical records in this case an actual urine drug screen that matched the date and time in this toxicology report?
A urine drug screen?
Yes, well, urine was taken from Ms. Benning. Did you find that in the medical records?
Yes, I saw urine was taken. I don't have it in front of me. I don't know the time, but I know it was taken on 2/25.
Did you find that it was consistent with what you saw here?
This was a blood.
In terms of this report?
So this was a blood sample.
I'm sorry, not urine, blood, yes.
So I did see in the medical records that there was blood taken. There were several orders of blood being ordered at the 22/31 in the ER medical records.
Yes, that's my apologies for speaking up. Now let's go now. You were talking earlier that I had showed you the comforter. Do you remember that?
Yes, ma'am.
And that would be toxicology report 231-29285. Do you remember that?
Yes, ma'am.
I want to show you now what would be considered the data from that report. Would that be consistent with that?
Yes, this is a summary page of the coca-ethylene.
And the comforter in this case, would that be the comforter that was recovered from Ms. Jade Benning's home?
According to the documentation provided in the literature packet, yes.
And did you learn that on that comforter, that Miss Benning had vomited on that comforter, according to what was told in the facts of this case?
Yes.
And as a result of that, did NMS perform testing on that vomit?
Yes.
And is this a result of the testing that was performed on that vomit?
It's one of them.
And did they find in that vomit cocaethylene or an indication thereof?
So yes, if I can, just to help the jury to see what you're looking at besides just a bunch of numbers. Sorry, switch the other way. Sorry. Yes.
Okay.
If you look at line item number 43 and 44, and what I'm looking at to identify this is the 007 number. And if you would show the cover page so that the jury can see where that number comes from.
You can go ahead, Molly.
Okay, so they extracted at the same time controls. So the low control is labeled 003. The case blank, so that would have been based on documentation, it was taken from an area completely away from where the vomit stain was, but of the same material in which they were extracting for this case to look at the vomit, and that was listed as 004. And then you have a high control, and that's listed as 005. And then they have a lab blank. So they took another piece of fabric or something from a case unrelated completely to this case and extracted it in the same manner. And that was listed as 006. And then 007 is the case sample. So that would be where the vomit would be taken from the stain and where the vomit is to the lead. And so that is how I then correlate looking at the data where we see the 007 1G1. The 1G1, all that is showing is the extraction vial that had been labeled so they can go back to their reports and such. And then the 1+99 is the 100 times dilution. And then the one below it, the 1+9, is the ×10 dilution from the original extracted liquid that they pulled off of a material. And then if you look under where it says nanograms per mil, where you see the 2.8, 2.6, we see that there's actually some values there. And if we scroll all the way to the far right, this one actually has the ion ratios in. And if we at the top, it'll say ion ratios out, yes means that they're out. And then if it says no, it means that they're in. So
you see that there?
yeah, so if we down a little bit, up. And then we want to look at the 1.9.
Let me scroll.
Yes, there we go. You can see all the no's on the side.
Okay.
So
And you said the 1.9?
the 1+9, so vial item 43, go up a little bit. Up. So the 05 is showing you that high calibrator. So they ran a calibrator at the same time as they ran the case sample to make sure that their calibrator is still reporting and responding the way they intended it to respond when they did the original extraction at the very beginning. So that's just the checks and balance for them.
Okay. And so is the ion ratio that we talked about before, is that present in this particular testing?
Yes.
Okay. And what does that tell you that is different than what the other test told you?
That this one would have been reported had it been above that LOQ or LOD. This is a reportable value.
And this was in fact found in the vomit of Ms. Benning on the evening of 2/25/23.
It was found on the comforter.
Thank you. Was there anything else of value that was found on the comforter from Ms. Benning?
That was found on the comforter?
In the vomit, yes.
No, I think that was it, that it was there, but it's below the reportable limit, and so it wasn't reported.
And what exactly would that have been that was there but was not above the reportable limit?
And that would, the fentanyl as well. And so
Is this you're looking at the number here?
Yeah, so 007, so that indicates us that is the case sample. We're not looking at a blank, we're not looking at a QC. And the 1+1 is a dilution of some sort that they're doing. I'm not sure what the dilution is, other than because they had to extract it from a solid material, probably into a water with some steps that they did. And then if you see the two windows on the top where it says fentanyl quant, the two on the left is the deuterated internal standard. So that is something that was put there to know that the instrument is responding correctly and is doing what it's supposed to. The two on the right under fentanyl quant is the sample of the unknown. So if you look at the one that's below it, it's hard to read because it's blurry. It says more fentanyl quant. That second one, how it just has a squiggly line and there's no actual peak there, then that's not there. But if you
give us a minute to see if we can fix it so that it can.
Yes. But you just need to see that those peaks are there. That's what the indication is. If it's not there and it's not indicated, then you would have what you look like there at the norfentanyl. You have to have both transitions for it to say that it is an indication that there is something there.
Okay. And so did you find that there was an indication of fentanyl in the vomit of Ms. Benning?
Yes, and I believe the concentration was very low.
Now, speaking of concentration, as a result of the type of testing that was performed on the vomit, are you able to quantify that vomit?
No.
And why is that?
The method that was used was a detective method. So you can't have the validation that needs to go through to do any kind of method extraction and method development for the instrument. It's a two-part, but they kind of go into one. A validation is at least 16 experiments. It looks at precision, it looks at bias, it looks at extraction, recovery, and all of that has to go into how they are able to report at the end of the day based on the reliability and such of the sample. And so if you have a qualitative assay, it is just that. It's present or it's not. You cannot assert any kind of number to it. And in this particular case, you really can't because the curve failed. Meaning you can't take, a curve is created with known concentrations to make a linear line. I like to kind of help you guys have an idea. If you remember, have kiddos that have elementary school and you were given an X and Y and you had two of them you had to find and you had to count across on your X and up to the Y or either way to find it. Think of that line as the calibration curve, and then the unknown is that X or Y that you're trying to track over to it. So if that curve is not successful and does not pass, then anything on that cannot be reliable. And so then you switch it to qualitative, and qualitative is just there. Quantitative is a number. And so it's present or it's not. You cannot put any kind of faith into the numbers that are produced from that report.
And so are you telling the jury that when it comes to the vomit, there was on Ms. Benning's comforter, that there was in fact an indication of fentanyl, and there was in fact an indication of cocaethylene?
Quantitatively, yes.
Now, the blood that was taken, as we were discussing previously, in regards to the litigation report 231268889, I asked you whether or not there was a corresponding date and time of blood collection for Ms. Benning. Do you remember that?
Yes, ma'am.
And that was in fact at the hospital for 225 at 2231. Is that correct?
Yes, ma'am.
Did you have an opportunity to look in the medical records to determine whether or not Ms. Benning had been given fentanyl at the hospital prior to that time?
There is notations in the medical records. It says that it was pulled and then it says it was wasted, and so I'm not clear if it was given or not.
And that's something for more of a medical professional to discuss, but
Yes.
I just wanted to know whether or not you had the opportunity to review that.
I did.
Let's now discuss whether or not, or tell me this, what does it take for you as a toxicologist that works in a laboratory to review records if you were to look over someone's work in order for you to sign your name to it? Can you tell this jury what all that would take?
Objection, Your Honor, to the relevance.
May I respond, Your Honor?
I'll overrule the judge. Go ahead.
So in my experience working in the laboratory, we've had people leave and had to review their work and whatnot. For myself to put my name on a report and take responsibility for that work, I looked specifically at the QCs. I looked at the calibration data or the qualitative data, whatever it is. But I looked at the entire case, and many times I would actually go to the instrument and I would look at the raw data. So there's printed computer data and then there's raw data. Raw data is what is done in the software. That's well above my knowledge as it comes off the instrument and it computes it into the computer. The reason I specifically would want to go look at that raw data is an analyst can manipulate that data and then it will print, and you don't know in many cases if that data was manipulated or not. So if I'm going to be putting my name on that paper, I want to make sure that that data is true as it is on the computer. I want to look and make sure that the entire batch had consistent results. So when you look at the lit packet does include the calibration and the controls, but we're only getting a snapshot of just this case. In many of these samples, there was hundreds of cases ran at the same time. So if you take a 35 millimeter film strip and you take out one picture, but what happened before or what happened after it, if I'm putting my name to sign out that case, I want to know that everything was before it, there was no problems with the instrument, there was no delays, there was no other issues, and correspondingly after it as well. And so it takes time to go through that data. Even doing this for 10 years, it still takes some time to review all of that.
And did you have an opportunity to look at the litigation packet as it relates to the litigation packet we were speaking of that ended in 889?
I did.
Do you remember how many pages of documents was that litigation packet?
I believe this one was around 1,900 pages.
1,912. Do you remember that specifically?
Yes.
Okay. And in your opinion, in order for an analyst to be able to review 1,912 pages of data, how long would you say that would take?
Just to review the lit packet and not look at the entire batch would take a significant amount of time.
Okay. What would be a significant amount of time?
To tell you, it took me almost an entire day just to go through just the lit packet myself and to look at everything and look at the controls, look at the responses, look and see if there's indications in the windows, and look at the entirety of just the lit packet. That's not looking at the entire batch.
And would you believe that you would be able to look at 1,912 pages in a fashion that you could sign off on it as having reviewed it in its entirety in less than 55 minutes?
Me personally, absolutely not.
Do you know of any situation in your experience as a laboratory toxicologist, with all that you know that it requires, any situation where that could be done based on your opinion?
It would be difficult to do a thorough review before putting a name on on the bottom of it and taking true ownership of that data.
Now, let's say that there was another packet that you needed to review, and that packet was over 2,600 pages. Given the same example and having to review both of those packets in less than an hour, would you believe that that would be possible?
Not to review the entire litigation packet and to do a thorough review of it.
Can you tell this jury exactly how many people actually have to perform testing in order for a toxicology report, let's say for 231268889, the one that's 1,912 pages, how many people perform tests in that litigation packet?
For NMS specifically, because every laboratory is different, NMS specifically, there was, I believe, 4 to 5 people who handled something in the preparatory of that sample. So from my understanding, I don't work at NMS, but from doing review and talking to colleagues that work there, it starts off with one person who receives the package, and then it goes to another person who does an aliquot. So it's a big science word. An aliquot is a sample of the whole. So if you think of a piece of pie and you take your slice of pie out, you've taken an aliquot of pie. And then they then put the rest of it aside. And I'm guessing so it's easier to maintain and move through. Doing 130 samples in one batch is significant a number of tubes you would be having. And then it goes to another person who preps the sample. And then it goes to another person who does the extraction for the sample. And then someone puts it on the instrument. And then someone reviews it coming off the instrument. And then it goes to the review person after that. And then it appears with Dr. Methune to release the report to the customer at the end. So it goes through multiple hands along the way.
I want to show you an example of both of those packets that I just discussed with you about the review of those packets. Can you see these packets here, or do I need to move them over there?
I can see them.
Okay. And so this is the data that is compiled in 2 of those packets. In your professional opinion, Dr. Jagari, can you review adequately everything that you explained, all those individuals who had to run through this testing and perform some of the data that goes along in here? And I'd like to just show the jury and orient them to some of the data that you must review.
Objection, Your Honor, this witness cannot authenticate data, and I object.
I'm not asking her to authenticate it.
I'm asking that anything be shown to the jury that has not
Okay,
been.
you're just asking to show.
I'm just asking a question.
You've already asked that question about the volumes.
And so this is just an example of all the data that's compiled in those litigation packets. It's not.
It is.
And does a analyst who signs off on this packet to sponsor that all of this information is correct, would they have to review all of this paperwork and data?
In my opinion, yes, before they put their name on it.
Can you do that in 53 minutes, Dr. Jagari?
Not unless you're a speed reader.
Thank you. I'll pass the witness.
Questions from the state?
Yes, Judge, because of the circumstances, can I have just 5 minutes?
Okay. If you'll step down the hallway, ladies and gentlemen.
You're appointing Joe Norman just to speak with Linda.
Yes, Your Honor.
Is that gonna be the case? Is she gonna need to listen to Dr. Mario Bartolome, Dr. Kelly Larkin, and Dr. Lindsay?
I believe that Dr. Carney is our expert that would be for the other three. It's
Oh,
just
okay.
Dr. Mifflin with this person. If I could just have a few minutes to speak to her.
Okay, all right, we'll take a 5-minute break. I guess hang her up there, she can call her on her cell phone.
Court's in a brief recess.
You know, I will be super happy when this trial is for real over. That lady's voice, that attorney, is so annoying. In my opinion, she's whiny. I can't have my way. Oh, poor baby. It's a trial. This isn't about you, lady.
Am I talking into the microphone? Okay.
Also, don't forget to like, share, and subscribe. Sorry, I'm just walking around here and I'm hearing this lady's whiny voice. Like, I don't understand why she's so whiny. Like I said, this is my opinion. I don't mean any bad things about her. She's probably a very nice lady. Okay, here we go.
Am I talking into the microphone?
Yeah.
Okay.
As far as we know.
Okay.
Dr. Collins, this is Carrie.
Dr. Benning, can you hear us?
Yes, I can.
Thank you.
All right, let the jury step there.
Ms. Collins, let's see those couple of black paperwork that you showed her when she says morning. I gave you the copies of this.
Would they be exhibits?
No.
No, they're already
Be
part of the record.
introduced.
I gave it to Ms. Pendleton.
Yeah, but there was one for the hospital blood. I didn't get that.
That one was actually the hospital, urine, not the blood.
Okay. Y'all have a seat.
This is the, I didn't show you this. This is the.
So you asked her about something, but you don't have that paperwork?
My witness answered my question, you can ask the witness.
Are you needing something, or are you ready?
No.
Okay.
Sorry, announce your name.
Dr. Gier.
Dr. Gier. Okay, Dr. Gier, do you actually do any lab assessments?
What do you mean by lab assessments?
You know, do you go to other labs and do you perform an assessment of the lab?
When I worked at the laboratory, I did the internal auditing of our own laboratory. So yes, I did do assessments. I don't do external assessments.
Okay, so you are not trained in assessing and reviewing another laboratory's standards and processes?
If you're asking if I am been through the ANAB assessor training, I have not.
You have not been through the ANAB assessor training.
I have not.
But you are here testifying about the processes of NMS labs.
I'm testifying to their data, yes.
Okay, but you are not trained as an ANAB lab assessor, correct?
Correct.
Okay, and did you know that Dr. Mithun is trained as an ANAB lab assessor?
Yeah, that's great.
So she actually goes to other labs outside of her own lab and she audits them for their standards and accreditation. And she has been trained in that. Did you know that?
No, I didn't.
Okay. You referenced that you reviewed the first hospital blood and you were talking about some seals. In your notes that defense counsel provided just before you testified, your notes under the report from Forensic Medical 2312-6889, you list what samples were submitted, and it says blood, in parentheses, Jade, liver, in parentheses, Jade, liver, in parentheses, baby. These are your notes.
Can I see that? Because I don't have a copy of that.
Sure.
Okay, and what was your question?
Your outline of notes, you list blood, in parentheses, Jade, liver, in parentheses, Jade, liver, in parentheses, baby, correct?
Yes.
Okay, so those are your notes reviewing these laboratory results, correct?
Yes.
Thank you. So apparently you are not aware that Jade's liver tissue was not submitted for testing, correct?
No, when I made that you're referring to, that was my work product. That was just stuff as I was looking at it, and I didn't know if that was Jade's or if it was the baby's, because there's two listings for the liver. There's the homogenate, and then there's the liver. So I didn't know what was what at the time when I made that list. I had since got clarification, and that is an older work product that I had. So that was not updated prior to my testimony for today.
You didn't update it when it was clear that it was only fetal tissue that was submitted. It was documented in multiple different places, but you didn't notice that. Going on to your comforter testimony, which again, you are not trained in any type of assessment for another lab, but would you at least agree with Dr. Mithun that reviewing data from your own lab is a different process than reviewing data from an outside lab? Would
Yes,
you
it
agree
can
with
be.
that? It doesn't take as much time because she is familiar with all of the NMS processes. Do you agree with her on that?
That could be true, yes.
Okay.
And Ms. Hollins took all this paperwork and stacked it up. The litigation packet is in no way, shape, or form required or relevant to do a specific case review. Don't you agree?
No, it should be.
Now, you were doing a case review to assist the defense with litigation. Dr. Mithun was looking at testing of a very specific case. She was doing a case review. You don't agree that those are two completely different things?
I think both reviews should be equally the same because as maybe I am reviewing for the defense, she's reviewing for the prosecution, and it should look at the entire batch and all of the quality controls and all of the standards and all of the paperwork to make sure that there is nothing that was missed within the other people's reviews.
Dr. Gear, you are very aware that what Dr. Mithun did was a separate forensic analysis. She wasn't doing it for the state. The state made a request that it be done. It is completely different than what you were doing for defense counsel.
We're both reviewing the litigation and reviewing the data to look at the accuracy, the reliability, and the dependability of that data.
Were you in the courtroom when Dr. Mithun testified?
I was.
Okay, and so her explanation for why she did not need to review the litigation packet, you think that's insufficient because you would do it?
Her testimony was she only looked at the case data and she looked at the summary pages. She did not look at the controls, she did not look at the calibration, and she did not look at any of the case blanks that were put in that run to assess if there was any carryover issues or any other instrumentation issues. She did look at a very specific part instead of looking at the completeness of the run.
So you must have missed the part where she testified that she had been reviewing the data in the casework for all of the reports since at least October of 2025.
I'm gonna object to argument, Your Honor.
Okay, she's asking, do you recall that?
I recall her testifying to that, yes.
And you also said that you were not sure what the dilution level is.
Which one are you referring to? There were several that had dilutions.
On the comforter samples, you're saying you don't know.
I don't know the factors in which they did the dilution. So when I worked in the laboratory, if we ran a dilution, we had to document, we took 5 grams to 15 mils of water to make that dilution, and we recorded that math. So anyone who was reviewing our documents could go back and know what factors and what dilutions we were doing and how we came to get to that dilution. All I have on this is a 1+1. I don't know the amount that it started with, and I don't know how much of the liquid solvent would have been added to it to allow for the dilution to take place.
Okay, well, that is what the dilution level is. If it's 1+1, if it's 1+9, it's 10. If it's 1+99, it's 100. And that is what is listed and documented in all of the NMS values.
I don't know the math.
You didn't understand how to interpret and do the math of 1+99.
No, I understood.
Okay, she can ask her question. Go ahead, you were answering.
No, I understand that it was not documented on where they derived to get to the 1+99 or to the 1+1. I don't know where she started from to get to that. So in my laboratory, when we would do, in this case, like the liver, we would take 5 grams of the liver plus 15 mils of water to get a 4 times dilution. That math was not provided for the dilution, so I don't know where it originated from.
So you're saying you don't know that it was a 10 times dilution and a 100 times dilution, that you couldn't interpret that? I don't have anything else.
Just briefly.
Brief, okay.
Very I wanted to just clear something up real quickly. If you remember, I asked you originally, were you aware of who the liver belonged to? Do you remember that question?
Yes.
And what did you say?
Originally, I did not.
And why not?
because of the way it was written on the submission form and the report, it had the same medical examiner number. It was later on that I learned that it may have been maybe marked wrong. It was the liver of the fetus, not of the decedent, as it appears on the report.
I want to show you. As it is listed here, does it say who the liver belongs to here?
It does not. In my previous experience working in a medical examiner office, if they come with the same labeled as number, it's from the same person, versus if it would have been the fetus in the laboratory I was in, it would have been given a daughter number or a separate number so that the testing could be separated.
And that is for litigation packet 231268889.
Yes, ma'am.
And did you see anywhere else where the liver was associated with the fetus of Miss Benning?
Only in the autopsy report.
And I apologize, my PowerPoint didn't work earlier, so I didn't have my paperwork, but you had asked me to give you this document so that you could assign the numbers to the diamond on the comforter. Do you remember that?
Yes, and it was to help the jury understand how I was able to look at the data and relate the data that was produced to the corresponding sample that was run at the same time.
So is this the data that you were speaking of?
Yes, so if you see where it says sample ID and then 003, and the next column labeled as flow control, and then it has the description of what that control or that item is, that's where I was using that report to look at the data to correspond the data to the appropriate item number.
Okay. And if you were to turn to the next page, because you were citing 007.
Yes, and you see where it's created from the fabric of the area with the visible stains, and it's labeled as the case sample.
Was there anywhere else on the comforter outside of the vomitus where fentanyl was found?
Yes, it was found in the case blank.
And would that be 004?
Yes, and again, the case blank is taken from the comforter, separate away from the stain of which they were testing for the case sample to make sure that the material was responding the same way.
And should fentanyl have any indication on the case blank? Or were they expecting in the test for fentanyl to show up on the case blank, if you know?
I would think no, because it's called a blank, which means it should be negative for any analyte in which you're looking for. It didn't say blank plus fentanyl, so.
Any other questions?
Just briefly.
Okay.
Again, Doctor, you were here when Dr. Mitten testified, correct?
Yes, ma'am.
And she testified about fentanyl being found in a very low number across the fabric. And she talked about the fact that that was kind of noise an issue and it did not mean anything. The level was so low. Do you recall that?
Actually, I think her testimony was that it was present and that it wasn't the noise because she saw both of the peaks in both windows and the ion ratio was in.
And she said there was absolutely none of it in the vomit, but it was something that showed up across the entirety of the fabric. Do you recall that?
I don't. I believe her testimony was that it was.
My question was, do you recall that? So you're saying you don't recall that that was her testimony?
Not that that was her testimony.
So she already testified about this, but you do agree that when you are looking at any of these levels, and you've talked about different levels without giving a ton of specific information, but it is a multi-point inspection. It is not just saying one value, one peak. You have to look at multiple variables that have to be present before it can be reported out. That's the entirety of the standardization and accreditation process.
Object the counsel testifying, is there a question?
I asked her if she agreed with that statement.
Go ahead, do you understand the question?
No.
You don't understand that when you are looking at lab values or a peak, that it is a multi-point inspection. You are looking at multiple variables and you have to have multiple things present before you can report out that it is a substance that you are finding. That is part of the standards and the accreditation process. If you report it when you don't have multiple variables, that would not be standard process and your lab would not be accredited. Do you agree with that?
I agree that there are multiple facets that need to be met for a analyte to be reported, and that's what the validation process covers. But there also it also has both transitions and both windows, and I believe her testimony said that it was present in the vomit.
Well, actually, the standards is part of what's in the litigation packet, which is part of the reason Dr. Minton doesn't need to review it, because she's familiar with the standards of NMS. So you didn't review the standards of NMS laboratories, is what you're saying?
They weren't provided in the litigation packet, ma'am.
I don't have anything else.
Okay, thank you, and you can step down.
Thank you for your time.
Rod. All right, ladies and gentlemen of the jury, we're going to break for lunch. Just remember what I've said about not discussing the case, forming any opinion, looking things up, all of those admonitions. We'll be back here at 1:50.
Telephone digital person.
Excuse me?
Our forensic digital person,
Who is that?
Eric Devlin.
And you provided a report from Lena Gill. We don't have anything from Eric Devlin.
As soon as he was going to testify to the report from Lena Gill, but.
From where? That admonition, we'll be back here at 1:50. Okay, and Ms. Holland, you said the other three expert or doctors that are listed here will be testifying, and then what about the other 1, 2, 3, 4, 5 people?
We will have the 3 doctors, Your Honor, and then, we'll have 3 doctors, and then we need to read into the record the deposition of Alyssa Smith. And then also we would have our forensic telephone digital person.
Excuse me?
Our forensic digital person,
Who is that?
Eric Devlin.
And you provided a report from Lena Gill. We don't have anything from Eric Devlin.
As soon as he was going to testify to the report from Lena Gill, but.
From where?
Lena Gill, but she's not testifying, and so we will provide the report from Mr. Devlin.
You have the report from Alina Gill?
I have a report from Lena Gill.
Okay.
I do not have anything from Eric Devlin.
But they're gonna have a surrogate witness.
Number, potentially a judge, but.
Okay, they're objecting to Mr. Devlin.
Why is that? He was noticed as an expert.
And video surveillance is what we were told.
He's a digital forensic expert, and we provided his CV.
Okay. You're wanting him to testify about what?
The telephone. Miss Bennett.
What
I'm
telephone?
sorry, Miss Benning.
The
Miss
text?
Bennett's telephone, yes.
Judge, I would ask for a jury out before they submit text messages to be introduced. The ones in the report.
Are you talking about the ones that have already been introduced?
No, these are others.
From when?
From the time period that we are allowed to be constrained.
About what?
So the state has put on evidence.
About what?
It will be about Ms. Benning dating other men. It will be about Ms. Benning's involvement with drugs. And it will be about Ms. Benning's involvement with drugs during her pregnancy.
Judge, the majority of the report is completely outside of January and February of 2023. They went all the way back to May of 2022 before she had ever even met
Okay.
Mr.
So
Taylor.
there's an objection about the relevancy, so we'll need to hear
We
from
will
Mr.
stay, will represent to the court that we will stay within the time period from when Ms. Benning met Mr. Taylor until February 25th.
The state has an objection to relevance, and I would ask for a jury out before she is allowed to call a witness,
Okay.
especially based
Have
on.
you got the text you're wanting to show Mr. Devon?
Yes,
And be giving them to the state?
we're adding a few, so based on the state's, presentation of evidence and their case in chief, we are
So
adding,
they've got everything but the few you're adding.
exactly.
Okay. And how do you define the few?
I'm not sure, I'll check and see where we are in a few minutes.
I mean, 2 or 50?
It would probably be more like 30 to 40, I'm sure, because they provided us with 30, and then when we got to trial, it was over 100.
Judge, I provided them updates. Mr. Brandon, I communicated, I sent him information.
Okay, you better get them printed out really quickly. So you have the 3 doctors and then Mr. Devon, is that it?
And the deposition of Alyssa Smith.
And who is Alyssa Smith?
She was the EMT that worked at
Oh.
Vanderbilt when Ms. Benning arrived at the hospital. She
And
is the
is
one.
that- Okay, I got it. Is that not the video? Okay, you said read into the record.
I wasn't sure how the court did it, so it doesn't matter.
If you have a recording, would just play it on your, through a thumb drive.
And then, we also have Dr. Brugalay.
Judge, before you write, the other doctors, are there any notes?
I thought they provided those in the emails.
We only have Larkin.
Is that the only person that has notes?
So I did, Dr.
That's just a simple question. Thought you said you were gonna have all of the others provided.
I've been in court, so I don't know the update of where they are.
All the
So
people that keep running in and out the door, did they get them?
if you give me an opportunity to ask them, I will.
Okay, go ahead. I'm not gonna wait with this jury here on stuff you haven't provided. Just won't come in.
We're not offering anything into evidence.
But they're entitled to Jeep's material,
I'm giving it to you.
and that's it.
That's it. That's all I have. She hasn't sent me anything.
She who?
Dr. Lindsay.
Is she here?
She is, you know what? There is a article that she sent.
Have your staff asked her if she's got notes?
Yes, they did.
And she doesn't have them.
That's what she provided.
Judge, those are allegedly notes.
Okay. So what do you want me to do?
I want you to exclude her as a witness. These are not notes. There's a couple scribbles on a piece of paper.
Okay, well, you can do your Carrie Mason moment with her.
Thanks, Judge.
So they have everything that these individuals are gonna say that they notated. Is that accurate?
That's what I don't have their notes. They've given me what they have.
Has your staff gotten everything from these additional 3 people that would be considered notes and or reports?
Your Honor, as far as I'm.
I'm not asking you, I'm asking the people that are here being paid to represent Mr. Taylor. Do they have it or not?
I explained to you that I gave them what they gave me. And I have to ask Ms. Lewis, because if I'm in questioning.
You were gonna ask Ms. Lewis.
Will you stop them from answering?
I'm not asking her, I'm asking you. Do they have everything that these 3 people have in terms of notes?
Yes, they do.
Thank you. You're right.
So they do?
Yes, they
Okay,
do.
certainly. So if something else comes in, then other than what they've got, you got a problem.
Yeah. Well, we have Devlin, of course.
Excuse me?
We have Devlin with his court, we have that. They don't have to make notes to
Get
justify.
them the text that you're adding, the few 30 that you've added, so we don't have to delay this jury trial anymore.
What's the let's recess?
Any idiot can tell that. It's not 2 liver samples, if it's 2 liver samples, it would say, mentioned arthritis, but I was C. Why does it matter? It's supposed to be blind testing. That's what, Karen was like, I don't know, is it A? Like, it was just a liver sample. She was like, I found out after when Dr. Carney called me about the results.
Right.
So we were talking over here, Dr. Carney. Because they told Judge that it was just their experts. And I'm pretty sure that they don't need just their experts today because they're not on the tomorrow and Wednesday.
That's with my interpretation. Right.
This is Josh over there, like, oh my God.
I know, this, yeah, that's right.
I know, I slipped on to Roger about the Clipper, things like that, but.
Yeah, I did. I think we should probably figure out.
This is for them to, from your email, it has much regularity, or whatever, I'll go to my signature on, and see what their explanation. It was an email you sent that said, I don't think they printed this out, which you were correct. The whole litigation.
I was like, she just handed me stuff and it's definitely not.
It was so hard to be, nothing had headers, nothing was organized. Thank you so much for
At useful there.
I didn't know, it wasn't like just a great there.
Do it all the time.
It's still on audio right now. That's not fair. I think that needs to be said. I was going to say really upset I didn't. 30 more text messages. Do we have them? Let me look at my.
Why are you still recording us?
Well, we had a hot mic going. That's why I didn't stop, because I was trying to hear what she was going to say. I'm telling you, man, she is a whiner. Oh, I don't know if I can deal with her, like, for real. She definitely's got some, like, it's not fair. What's not fair? That you can't always get your way? I mean, this is a man's life on the line. Things need to be really accurate. I mean, come on. Do you think it's fair for him? Just so everybody remembers, I'm always the one for innocent until proven guilty. So they got to prove to me that he's guilty by a jury of his peers. So I'm making cinnamon rolls, y'all. Pretty sure I just went the wrong way. Darn it. I can't come over there and click anything because my hands are dirty. They're full of sugar. Sugar, butter, and cinnamon. I hope everyone's enjoying the trial. I think after this one, I'm going to Probably take a break for the rest of the month from streaming. Not that I don't think people are watching, it's just I'm not getting enough viewers. And people recommend the trials to me, and then they don't even watch it with me. So the $44 a month is definitely not. It's too much for me right now, especially when people aren't really watching the trial. I think people are watching the replay, but I like people to be here, so I have someone to talk to, you know? Kind of sucks that I have no one to talk to. Now I guess I'm being a whiner. Not meaning to be. I mean, I'm happy. I did it on my little counter, and I probably should have. I really didn't give myself enough room. I don't stay close. My daughter has to come and I have to re-sign her marriage license because yesterday when her new wife was signing the marriage license, she was so nervous. I don't know what she did, but did something to the deed, and the courthouse won't accept it. So she has to refill out the license, which is, thank God it's only $1 and not the $25. But y'all, I think I'm going to end this and come back in the hour. And I'll be back, okay? Thanks so much for being here. Don't forget to like, share, and